We're at section 4 here. Insurance companies or others doing business in the United States. Section 4. A. Every enemy or ally of an enemy insurance or reinsurance company and every enemy or ally of an enemy doing business within the United States through an agency or branch office or otherwise may within 30 days after the passage of this act apply to the President for a license to continue to do business, and within 30 days after such application the President may enter an order either granting or refusing to grant such license. The license, if granted, may be temporary or otherwise, and for such periods of time, and may contain such provisions and conditions regulating the business, agencies, managers, and trustees, and the control and disposition of the funds of the company or of such enemy or ally of the enemy as the President shall deem necessary for the safety of the United States, and any license granted hereunder may be revoked or regranted or renewed in such manner and at such time as the President shall determine, provided, however, that reasonable notice of his intent to refuse to grant a license or to revoke a license granted to any reinsurance company shall be given by him to all insurance companies incorporated within the United States and known to the President to be doing business with such a reinsurance company, provided further that no insurance company organized within the United States shall be obligated to continue any existing contract entered into prior to the beginning of the war with any enemy or ally of the enemy insurance or reinsurance company, but any such company may abrogate and cancel any such contract by serving 30-day notice in writing upon the President of its election to abrogate such contract. For a period of 30 days after the passage, this is lawful to continue business 30 days. For a period of 30 days after the passage of this act, and further pending the entry of such order by the President, after application made by any enemy or ally of an enemy, insurance or reinsurance company within such 30 days as above provided, the provisions of the President's proclamation of April 6, 1917, relative to agencies in the United States, certain insurance companies, as modified by the provisions of the President's proclamations of July 13, 1917, relative to marine and war risk insurance, shall remain in full force and effect so far as it applies to such German insurance companies, and the conditions of said proclamation of April 6, 1917, as modified by said proclamation of July 13, 1917, shall also during said period of 13 days after the passage of this act and pending the order of the President as herein provided, apply to any enemy or ally of the enemy insurance or reinsurance company anything in this act to the contrary notwithstanding, it shall be unlawful for any enemy or ally of the enemy insurance or reinsurance company to whom license is granted to transmit out of the United States any funds belonging to or held for benefit of such company, or to use any such funds as the basis for the establishment directly or indirectly of any credit within or outside of the United States to or for the benefit of or on behalf of or on account of any enemy or ally of the enemy for a period of 30 days after the passage of this act, and further pending the entry of such orders by the President after application made within such 30 days. By any enemy or ally of an enemy other than an insurance or reinsurance company as above provided, it shall be lawful for such enemy or ally enemy to continue to do business in this country, and for any person to trade with, to from, for, on account of, on behalf of, or for the benefit of such enemy or ally of an enemy, anything in this act to be contrary notwithstanding, provided, however, that the provisions of Section 3 and 16 hereof shall apply to any act or attempted act of transmission or transfer of money or other property out of the United States, and to the use or attempted use of such money or property as the basis for the establishment of any credit within or outside of the United States to or for the benefit of or on behalf of or on account of an enemy or ally of an enemy, unlawful to continue business without a license. If no license is applied for within 30 days after the passage of this act, or if a license shall be refused to any enemy or ally of an enemy, whether insurance or reinsurance company or other person making an application, or if any license granted shall be revoked by the President, the provisions of Section 3 and 16 hereof shall forthwith apply to all trade, or to any attempt to trade with, to, from, for, by, on account of, or on behalf of, or for the benefit of such company or other persons, provided, however, that after such refusal or revocation, anything in this act to the contrary notwithstanding, it shall be lawful for a policyholder or for an insurance company, not an enemy or ally of an enemy, holding insurance or having effected reinsurance in or with such enemy or ally of an enemy insurance or reinsurance company, to receive payment of and for such enemy or ally of an enemy insurance or reinsurance company, to pay any premium, return premium, claim money, security, or other property due or which may become due on or in respect to such insurance or reinsurance in force at the date of such refusal or revocation of license, and nothing in this act shall vitiate or nullify then existing policies or contracts of the insurance or reinsurance or the condition thereof, and any such policy holder or insurance company, not an enemy or ally of an enemy, having any claim to or upon money or other property of the enemy or ally of the enemy, insurance or reinsurance company, in the custody or control of the alien property custodian hereinafter provided for or of the Treasury of the United States, may make application for the payment thereof, and may institute suit as provided in Section 9 hereof. B. Change of name. That during the present war, no enemy or ally of an enemy, and no partnership of which he is a member or was a member at the beginning of the war, shall for any purpose assume or use any name other than that by which such enemy or partnership was ordinarily known at the beginning of the war, except under license from the President. Whenever during the present war, in the opinion of the President, the public safety or public interest requires, the President may prohibit any or all foreign insurance companies from doing business in the United States, or the President may license such company or companies to do business upon such terms as he may deem proper. Suspension of provisions applicable to an ally of an enemy. Section 5A. That the President, if he shall find it compatible with the safety of the United States and with the successful prosecution of the war, may by proclamation suspend the provisions of this act so far as they apply to an ally of enemy, and he may revoke or renew such suspension from time to time, and the President may grant licenses, special or general, temporary or otherwise, and for such period of time, and contracting such provisions and conditions as he shall prescribe to any person or class of persons to do business as provided in Section A, subsection A of Section 4 hereof, and to perform any act made unlawful without such license in Section 3 hereof, and to file and prosecute applications under subsection B of Section 10 hereof, and he may revoke or renew such license from time to time, if he shall be of the opinion that such grant or revocation or renewal shall be compatible with the safety of the United States and with the successful prosecution of the war, and he may make such rules and regulations not inconsistent with law as may be necessary and proper to carry out the provisions of this act, and the President may exercise any power or authority conferred by this act through such officer or officers as he shall direct. Suspension of performance of illegal act and export of coin or bullion. If the President shall have reasonable cause to believe that any act is about to be performed in violation of Section 3 hereof, he shall have authority to order the postponement of the performance of such act for a period not exceeding 90 days, pending investigation of the facts by him. B, that the President may investigate, regulate, or prohibit under such rules and regulations as he may prescribe by means of license or otherwise any transaction in foreign exchange, export, or earmarking of gold or silver coin or bullion or currency, transfers of credit in any form other than credit relating solely to transactions to be executed wholly within the United States, and transfers of evidence of indebtedness or of the ownership of property between the United States and any foreign country, whether enemy, ally of an enemy, or otherwise, or between residents of one or more foreign countries by any person within the United States, and he may require any such person engaged in such transactions to furnish under oath complete information relative thereto, including the production of any books of account, contracts, letters, or other papers in connection therewith, in the custody or control of such person, either before or after such transaction is completed. Alien property custodian. Section 6. That the President is authorized to prescribe the duties of, and affix the salary not to exceed $5,000 per annum of an official to be known as the alien property custodian, who shall be empowered to receive all money and property in the United States due or belonging to an enemy or ally of enemy, which may be paid, conveyed, transferred, assigned, or delivered to said custodian under the provisions of this act, and to hold and administer and account for the same under the general direction of the President, and as provided in this act, the alien property custodian shall give such bond or bonds, and in such form and amount, and with such security as the President shall prescribe. The President may further employ in the District of Columbia and elsewhere and fix the compensation of such clerks, attorneys, investigators, accountants, and other employees as he may find necessary for the due administration of the provisions of this act, provided that such clerks, investigators, accountants, and other employees shall be appointed from lists of eligibles to be supplied by the Civil Service Commission, and in accordance with the Civil Service law, provided further that the President shall cause a detailed report to be made to Congress on the first day of January of each year of all proceedings had under this act during the year preceding. Such report shall contain a list of all persons appointed or employed with the salary or or compensation paid to each, and a statement of the different kinds of property taken into custody and the disposition made thereof. Section 7. Disclosure of stockholders, directors, and officers of corporations. Section 7A. That every corporation incorporated within the United States and every unincorporated association or company or trustee or trustees within the United States issuing shares or certificates representing beneficial interest shall, under such rules and regulations as the President may prescribe, and within 60 days after the passage of this act, and at such other times thereafter as the President may require, transmit to the alien property custodian a full list duly sworn to of every officer, director, or stockholder known to be or whom the representative of such corporation, association, company, or trustee has reasonable cause to believe to be an enemy or ally of an enemy resident within the territory, or a subject or citizen residing outside of the United States of any nation with which the United States is at war, or resident within the territory, or a subject or citizen residing outside of the United States of any ally or of any nation with which the United States is at war, together with the amount of stock or shares owned by each such officer, director, or stockholder, or in which he has any interest. The President may also require a similar list to be transmitted of all stock or shares owned on February 3rd, 1917 by any person now defined as an enemy or ally of an enemy, or in which any such person had any interest, and he may also require a list to be transmitted of all cases in which said corporations, associations, company, or trustee has reasonable cause to believe that the stock or shares on February 3rd, 1917 were owned or are owned by such enemy or ally of an enemy, though standing on the books in the name of another, provided, however, that the name of any such officer, director, or stockholder shall be stricken permanently or temporarily from such list by the alien property custodian when he shall be satisfied that he is not such enemy or ally of an enemy. Disclosure of money and property or property. Any person in the United States who holds or has or shall hold or have custody or control of any property, beneficial or otherwise, alone or jointly with others, of, for, or on behalf of any enemy or ally of the enemy, or for any person whom he may have reasonable cause to believe to be an enemy or ally of an enemy, and any person in the United States who is or shall be indebted in any way to an enemy or ally of an enemy, or to any person who he may have reasonable cause to believe to be an enemy or ally of an enemy, shall, with such exceptions and under such rules and regulations as the President may prescribe, and within 30 days after the passage of this act, or within 30 days after such property shall come within his custody or control, or after such debt shall become due, report the fact to the alien property custodian by written statement under oath containing such particulars as said custodian shall require. The President may also require a similar report of all property so held of, for, or on behalf of, and of all debts so owed to any person now defined as an enemy or ally of an enemy on February 3rd, 1917, provided that the name of the enemy, provided that the name of any person shall be stricken from the said report by the alien property custodian, either temporarily or permanently, when he shall be satisfied that such person is not an enemy or ally of an enemy. Gee, it sure seems like a really damn good idea to be letting the alien property custodian know through an amnesty oath that you're not an enemy or an ally of an enemy. It is not your intent. You're going to state your intent. It's your free will act and deed to notify them, to let them know that you're not an enemy, belligerent combatant of the United States, nor are you, or is it your intent to aid and abet any enemy or ally of the enemy of the United States, right? Extensions of time for filing list. The President may extend the time for filing the list or reports required by this section for an additional period not exceeding 90 days. Effect of law on unlawful transactions. B. Nothing in this act contained shall render valid or legal or be construed to recognize as valid or legal any act or transaction constituting trade with, to, from, for, or on account of, or on behalf of, or for the benefit of an enemy performed or engaged in since the beginning of the war and prior to the passage of this act, or any such act or transaction hereafter performed or engaged in except as otherwise hereunder, which would otherwise have been or be void, illegal, or invalid at law. No conveyance, transfer, delivery, payment, or loan of money or other property in violation of Section 3 hereof made after the passage of this act, and not under license as herein provided, shall confer or create any rights or remedy in respect thereof. And no person shall, by virtue of any assignment, endorsement, with an I, not an E, or delivery to him of any debt, bill, note, or other obligation, or chose in action by, from, or on behalf of, or on account of, or for the benefit of an enemy or ally of an enemy, have any right or remedy against the debtor, obligor, or other person liable to pay, fulfill, or perform the same unless said assignment, endorsement, or delivery was made prior to the beginning of the war or shall be made under license as hereinafter provided, or unless, if made after the beginning of the war and prior to the date of passage of this act, the person to whom the same was made shall prove lack of knowledge and of reasonable cause to believe on his part that the same was made by, from, or on behalf of, or on account of, or for the benefit of an enemy or ally of an enemy, and any person who knowingly pays, discharges, or satisfies any such debt, note, bill, or other obligation, or chosen action shall, on conviction thereof, be deemed to violate sections 3 hereof, provided that nothing in this act contained shall prevent the carrying out, completion, or performance of any contract, agreement, or obligation originally made with or entered into by an enemy or ally of an enemy prior to the beginning of the war, and not in contemplation thereof. The interest of such enemy or ally of an enemy devolved by assignment or otherwise upon a person not an enemy or ally of an enemy, and no enemy or ally of an enemy will be benefited by such carrying out, completion, or performance otherwise than by release from obligation thereunder. Payments prior to the war. Nothing in this act shall be deemed to prevent payment of money belonging or owing to an enemy or ally of an enemy to a person within the United States, not an enemy or ally of an enemy, for the benefit of such person or of any other person within the United States, not an enemy or ally of an enemy, if the funds so paid shall have been received prior to the beginning of the war, and such payments arise out of the transaction entered into prior to the beginning of the war, and not in contemplation thereof, provided that such payment shall not be made without the license of the President, General, or Special, as provided in this act. Nothing in this act shall be deemed to authorize the prosecution of any suit or action at law or in equity in any court within the United States by an enemy or ally of an enemy prior to the end of the war, except as provided in Section 10 hereof. Provided, however, that an enemy or ally of an enemy licensed to do business under this act may prosecute and maintain any such suit or action so far as the same arises solely out of the business transacted within the United States under such license, and so long as the license remains in full force and effect. And provided further that an enemy or ally of the enemy defended by counsel any suit in equity or action at law which may be brought against him. So again, you have to have counsel until you notify the Attorney General, the Office of the President of the United States, the Secretary of State, and the Secretary of Treasury that you're not an enemy, belligerent combatant of the United States. You are required to have counsel, okay? Receipt of notice from the President to the effect that he has reasonable ground to believe that any person is an enemy or ally of an enemy by prima facie defense to anyone receiving the same in any suit or action at law or in equity, brought or maintained, or to any right of or set off or recoupment asserted by such person, and based on failure to complete or perform since the beginning of the war any contract or other obligation. In any prosecution under Section 16 hereof, proof of receipt of notice from the President to the effect that he has reasonable cause to believe that any person is an enemy or ally of an enemy shall be prima facie evidence that the person receiving such notice has reasonable cause to believe such other person to be an enemy or ally of the enemy within the meaning of Section 3 hereof. Surrender of enemy property. C. If the President shall require any money or other property owing or belonging to or held for, by, on account of, or on behalf of, or for the benefit of an enemy or ally of an enemy not holding a license granted by the President hereunder, which the President after investigation shall determine is so owing or so belongs or is so held, shall be conveyed, transferred, assigned, delivered, or paid over to the alien property custodian. D. If not required to pay, convey, transfer, assign, or deliver under the provisions of subsection C hereof, any person not an enemy or ally of an enemy who owes to or holds for or on account of or on behalf of or for the benefit of an enemy or of an ally of an enemy not holding a license granted by the President hereunder, any money or other property, or to whom any obligation or from form of liability to such enemy or ally of an enemy is presented for payment, may at his own option, with the consent of the president, pay, convey, transfer, assign, or deliver to the alien property custodian said money or other property under such rules and regulations as the president shall prescribe. E. No person shall be held liable in any court for or in respect to anything done or omitted in pursuance of any order, rule, or regulation made by the president under the authority of this act. Delivery to custodian, full discharge of obligation. Any payment, conveyance, transfer, assignment, or delivery of money or property made to the alien property custodian hereunder shall be a full acquittance and discharge for all purposes of the obligation of the person making the same to the extent of the same. The alien property custodian and such other person as the president may appoint shall have power to execute, acknowledge, and deliver any such instrument or instruments as may be necessary or proper to evidence upon the record or otherwise such acquittance and discharge, and shall, in case of payment to the alien property custodian of any debt or obligation owed to an enemy or ally of an enemy, deliver up any notes, bonds, or other evidence of indebtedness or obligations or any security thereof in which such enemy or ally of an enemy had any right or interest that may have come into the possession of the alien property custodian, with like effect as if he or they respectively were duly appointed by the enemy or ally of the enemy, creditor or obligee. The president shall issue to every person so appointed a certificate, that'd be your birth certificate, of the appointment and authority of such person, and such certificate shall be received in evidence in all courts within the United States whenever any such certificate of authority shall be offered to any register, clerk, or other recording officer, federal or otherwise, within the United States. Such officer shall record the same in like manner as the power of attorney, and such record or duly certified copy thereof shall be received in evidence in all courts of the United States or other courts within the United States. Ladies and gentlemen, that is 40 Statute at Large 411, Section E, found on page 418 in the Statute at Large. But again, here it is right here in the Trading with the Enemy Act. All right. So this is where you want to grab it out of. But if you want to cement it in time and place, Title I, Section 112 of Title I states that statutes at large are legal evidence in all courts from the highest to the lowest, in all jurisdictions from ecclesiastical to maritime and admiralty jurisdiction. All right. It doesn't matter if you're in a probate court, small claims court, district court, appellate court, Supreme Court, Superior Court. It doesn't make a damn bit of difference. All right. Listen to what I'm saying here. All right. Delivering everything to the custodian, the alien property custodian holder. All right. And making sure that they vet the people that you're doing business with to ensure that you're not aiding and abetting the enemy of the United States is in your interest. Remember, the United States Treasury, you're a preferred stockholder. And that's the other thing the birth certificate is. It's evidence that you're a preferred stockholder. Okay. So comprehending this is quintessential. It's key to establishing your status and standing. Remember, an enemy or ally of an enemy can't bring suit in the United States. And an enemy or an ally of an enemy must retain counsel. Okay, so it might benefit you and behoove you to go ahead and put the Secretary of State on notice, the Attorney General on notice, the Office of the President of the United States on notice, the Secretary of the Treasury on notice. All right, federal and state level, ladies and gentlemen, put them on notice. What's up? Here's my amnesty oath. All right, I'm an American. I'm an American citizen. I'm federally protected. I have unalienable rights. I am one of we the people. The Constitution does draw a line in the sand to ensure that none of the agents and agency out there can cause harm, damage, or loss without being held liable for it. All right. The Federalist Papers, I am privy to. The international law, I am privy to. All right. And it draws a line in the sand for my protection to ensure that I'm not caused harm, damage, and loss. And in the event that I am caused harm, damage, and loss, the Treasury of the United States has first instance in bringing claim, and then I have second interest in bringing claim after the fact, because first and foremost, we want to make sure the Treasury is always made whole and bringing down the national debt, for Pete's sake. Okay? Section 8, enforcement of liens. Section 8, A, that any person, not an enemy or ally of an enemy, holding a lawful mortgage, pledge, or lien, or other right in the nature of a security and property of an enemy or ally of an enemy, which by law or by the terms of the instrument creating the mortgage, pledge, or lien or right may be disposed of on notice of presentation or demand, and any person not an enemy or ally of an enemy who is a party to any lawful contract with an enemy or ally of an enemy, the terms of which provide for a termination thereof upon notice or for acceleration of maturity on presentation or demand, may continue to hold said property. Can I get an amen? And after default may dispose of the property in accordance with law, or may terminate or mature such contract by notice or presentation or demand served or made on the alien property custodian in accordance with the law and the terms of such instrument or contract, and under such rules and regulations as the President shall prescribe, and such notice and such presentation and demand shall have in all respects the same force and effect as if duly served or made upon the enemy or ally of the enemy personally. Provided that no such rule or regulation shall require that notice or presentation or demand shall be served or made in any case in which, by law or by the terms of said instrument or contract, no notice, presentation, or demand was prior to the passage of this act required, and that in case where by law or by the terms of such instrument or contract notice is required, no longer a period of notice shall be required. Provided further that if on any such disposition of property a surplus shall remain after the satisfaction of the mortgage, pledge, lien, or other right in the nature of security, notice of that fact shall be given to the President pursuant to such rules and regulations as he may prescribe, and such surplus shall be held subject to his further order. Abrogation of enemy contracts. B, that any contract entered into prior to the beginning of the war between any citizen of the United States or any corporation organized within the United States and any enemy or ally of an enemy, the terms of which provided for the delivery during or after any war in which a present enemy or ally of the enemy nation has been or is now engaged, of anything produced, mined, or manufactured in the United States, may be abrogated by such citizen or corporation by serving 30 days notice in writing upon the alien property custodian of his or its election to abrogate such contract. Suspension of statute of limitations. C, the running of any, whoops, hold on, where'd my mouse go? Oh, dang, I lost it. There we are. Well, my mouse went to shit. Damn it, furry little rat. C, the running of any statute of limitations shall be suspended with reference to the rights or remedies of any contract or obligation entered into prior to the beginning of the war between parties, neither of whom is an enemy or ally of an enemy, and containing any promise to pay or liability for payment which is evidenced by draft or other commercial paper drawn against or secured by funds or other property situated in an enemy or ally of an enemy country, and no suit shall be maintained on any such contract or obligation in any court within the United States until after the end of the war, or until the said funds or property shall be released for the payment or satisfaction of such contract or obligation, provided, however, that nothing herein contained shall be construed to prevent the suspension of the running of the statute of limitation in all other cases where such suspension would occur under existing law. Whoops, bear with me here. Bing, bing, bing. Section 9, claims against property deposited with the custodian. This is important. Section 9, that any person, not an enemy or ally of an enemy, claiming an interest, right, or title in any money or other property which may have been conveyed, transferred, assigned, delivered, or paid to the alien property custodian hereunder and held by him or by the treasurer of the United States, or to whom any debt may be owing from an enemy or ally of an enemy whose property or any part thereof shall have been conveyed, transferred, as assigned, delivered, or paid to the alien property custodian hereunder and held by him or by the treasurer of the United States, may file with the said custodian a notice of his claim under oath, and in such form and containing such particulars as the said custodian shall require, and the president, if application is made therefore by the claimant, may, with the assent of the owner of said property and of all persons claiming any right, title, and interest therein, order the payment, conveyance, transfer, assignment, or delivery to said claimant of the money or other property so held by the alien property custodian or by the treasurer of the United States, or of the interest therein to which the president shall determine said claimant is entitled. All right, this is important because guess what? Guess where your estate is being held? It's being held by the alien property custodian after it was registered in the Federal Registry. Okay? So, provided that no such order by the president shall bar any person from the prosecution of any suit at law or in equity against the claimant to establish any right, title, or interest which he may have in such money or other property, if the president shall not so order within 60 days after the filing of such application, or if the claimant shall have filed the notice as above required and shall have made no application to the president, said claimant may, at any time before the expiration of 6 months after the end of the war, institute a suit in equity in the District Court of the United States for the district in which such claimant resides, or if a corporation where it has its principal place of business, to which suit the alien property custodian or the treasurer of the United States, as the case may be, shall be made a party defendant, to establish the interest, right, title, or debt so claimed, and if suit shall be so instituted, then the money or other property of the enemy or ally of the enemy against whom such interest, right, or title is asserted, or debt claimed, shall be retained in the custody of the alien property custodian or in the treasury of the United States as provided in this act, and until any final judgment or decree which shall be entered in favor of the claimant shall be fully satisfied by payment or conveyance, transfer, assignment, or delivery by the defendant or by the alien property custodian or treasurer of the United States on order of the court, or until final judgment or decree shall be entered against the claimant or suit otherwise terminated. Property not subject to lien while with custodian, except as herein provided, the money or other property conveyed, transferred, assigned, delivered, or paid to the alien property custodian shall not be liable to lien, attachment, garnishment, trustee process, or execution, or subject to any order or decree of any court. This section shall not apply, however, to money paid to the alien property custodian under Section 10 hereof. Section 10, enemy may apply for letters patent. When we come back, we'll get into Section 10. I gotta go fix my mouse.